presiding. All persons that have business before the court draw near, give attention, you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good afternoon. Welcome to an oral argument session of the 5th District Court of Appeal. I've already been introduced. I would like to introduce the members joining me on the panel, Judge Scott Makar from Duval County and Judge Jordan Pratt, also from Duval County. I am going to assume that the appellant would like 5 minutes for rebuttal unless I hear differently, Mr. Grassley. And if I could just have anybody who's observing in the courtroom make sure whatever devices you have that may make an inadvertent noise, you put that on mute so it doesn't interrupt the parties in their presentation. And with that, Mr. Grassley, is 5 minutes okay?
It's an aspirational goal, Your Honor.
Okay, all right. We all aim, so all right. You may proceed.
Good afternoon. May it please the court. I'm Bill Grassley from Jacksonville on behalf of Marcia and Larry Adams, who are the plaintiffs below, the appellants here. I know the court's familiar with the sort of the general background of the case. We have a subdivision where multiple lots have riverfront and their own right to build a dock, and then we have an upland lot referred to as Tract A that 3 owners, my clients, the appellee, Mr. Day, and then the nominal appellees, the Goulion McKenzie, own the other 3 lots. The covenants and restrictions provide them with sole exclusive rights to use and access the Tract A uplands and exclusive rights of use of the dock that they were going to share. This whole issue arose initially by Mr. Day buying his lot and deciding he wanted to put his boat slip where my clients had already agreed with the developer they would put it, and they eventually worked that out. That was the first part of the agreement. But the real starting point for the legal arguments here are a couple of factual inaccuracies contained in the order under review, which is the order granting the defendant's motions for summary judgment, and the legal errors made by the court below.
Mr. Grassley, what is your foundation or your evidentiary support for what was the actual agreement between the 3 parties as it concerned the dock? And specifically, you're making an allegation or an assertion that there was unanimity that was required with regard to that.
And those
so where do you get there with the contract?
Okay, the parties' agreement was put together over a period of several months, March through May of 2018, by a series of emails. And Mr. Seberg was the president of the Homeowners Association, and the agreement was not just between the 3 lot owners. It was also involved the Homeowners Association, who was an appellee and is represented here today. The agreement, you'll find it at Exhibit A, Record 57 through 60, shows the allocation of the boat slips. I'm sorry, excuse me. And the plans that were submitted to Mr. Spar, S-P-A-H-R, who was the professional engineer who was hired by the Homeowners Association to draw up the final plan and submit it to the state. The state owns the lands under the ordinary high water mark. The submerged lands lease had to be extended, and approval of the dock construction. To put this in the correct perspective, there's a couple of statements that are made in the order under review that need to be clarified. On page 5, which is Record 875, Judge Maltz says, Day sought to extend the dock in front of a boat slip at the common dock and to add a roof over that boat slip. Well, that's accurate. He made application to the Architectural Review Committee, ARC. He did not. He worked with them for a while, and then at the end of that process, he and Mr. Seberg, the president of the Homeowners Association, decided they were going to have a new plan. And so the emails from May 15th on have to do with the 3 owners agreeing, and the Goulions, he said, I'll do whatever anybody wants, that's okay. So he's played no role below or here.
So going to the agreement, was there any bargain for exchange I understand that there's this series of emails that talks about, doing things, with unanimity. But I mean, what principle of law, in your view, makes that agreement, as you're calling it, legally enforceable?
Well, we have a dock that was, a portion of which was built when the parties bought their lots. We have Section 53 of the Declarations of Covenants and Restrictions as amended twice.
So maybe a different way to ask the question is, does this agreement add anything to your argument?
This agreement provides the basis for how the parties can exercise the rights that are granted to them exclusively under the covenants and restrictions.
Right, but to determine that, though, we look to the covenants and restrictions themselves, right? We read
To start with, because they're the ones that provide the reason that these three parties are in a legal relationship. They're co-owners, co-beneficiaries of an exclusive right of use and access to a waterfront lot and a dock. The problem here is twofold. One is the judge said Day obtained all the necessary permits, inspections, and approvals for the construction.
Going back just a quick second to the agreement.
Didn't happen.
Are you treating this agreement as, let's call it maybe extrinsic evidence about the meaning of the covenants and restrictions? That, because the parties have dealt in a certain way, that is supposed to shed light on how we're to interpret the relevant paragraphs of the declaration, or is it some other
I think that
relevance?
it's the other way around. The covenants and restrictions, and in particular Section 53, is what establishes the relationship between these parties. They're co-owners of something. They're co-owners of an easement, exclusive easement, through a riverfront lot that is owned, the title is owned by the homeowners association, who has to be the one to apply for permits, and they have the right to use the dock. The dock was bare bones. It was just a dock. There was no boat slips allocated. There was no anything else. So by necessity, for these parties to exercise the rights that they bought when they bought their lots, subject to the covenants and restrictions, they had to figure out, how do we go about getting a plan to use the dock, to put in boat slips and whatever else they want. The judge says that the association approved this. What happened was that Chris Seaberg, the president of the association, and Mr. Day decided, after the Architectural Review Committee had come up with some specifications and guidelines, that we're going to do something different. And the emails show that everybody signed off on that. The thing that is being missed in this order under review, factually, is, and this is on 876, he said this was approved. The plaintiffs seek injunctive relief, seeking removal of disputed section of roof. That's fact. But the other part of this is that, excuse me, the homeowners association took no role once the approval was given by all the owners to Mr. Spar to go build the dock. What happened was that Mr. Day changed what was submitted to the state and built not only the agreed upon 10-foot extension, which was supposed to be a common area of all the dock, but he put a roof on it attached to the boat slip roof that he had showed on the plans. And that's the problem here, is that the judge sort of ignored that what was agreed to and what was submitted to the state for permitting and what was permitted got changed unilaterally by Mr. Day.
Did you ever argue to the trial court the failure of the trial court to find the existence of the agreement and the terms of the agreement? That was not fully argued in front of the trial court, is that correct?
Well, I don't agree with that in whole, Your Honor. I think that the arguments that were made in the motion for rehearing and reconsideration by the Adams Trial Counsel, which was not me, was that you didn't even find an agreement, and that's what we sought declaratory relief on, that there was an agreement, that it had to be exercised in part by unanimity. And that's the part of this that is the most troublesome legally, and I say troublesome, it's the most egregious error. Judge Wallace, last year you were on a panel in a family law case, Holland v. Holland, where we had an issue, a Daubert issue, about exclusion of evidence from the treating physician. And you referred to the judge's error as mind-numbing. I submit that the error in the trial court's interpretation of Section 53 of the Declarations of Covenants and Restrictions is mind-numbing. What Judge Maltz says is, well, you're asking me, plaintiffs, to insert a provision in paragraph 53 that requires unanimity of the three boat dock owners, how the dock's going to be modified. No. The Section 53 says unequivocally that they have exclusive, equal, sole rights. How do you come up from there with saying, but each owner can do whatever they want? The whole entire subdivision is governed by covenants and restrictions. It's got an architectural review committee of the board to ensure uniformity, ensure the quality of construction is consistent, all of the things that covenants and restrictions do.
The word unanimous or any synonym for unanimous is not used in Section 53.
That's correct, and it's my position, Your Honor, that it's inescapable. You cannot have a grant of an exclusive sole right given to three people and then say, but they don't have to agree to do anything. They can go do whatever they want. That's the position of the appellees here, is that it doesn't matter. Mr. Day, in his affidavit in opposition to the plaintiff's motion for summary judgment on the deck action, said, yeah, I built stuff that wasn't originally proposed, but I paid for it so nobody gets to complain. That's the choice that we've got here.
Well, another argument would be we have to look to the agreement and what are the terms of the agreement. And getting back to the question that Judge Pratt asked, there needs to be a bargain for consideration, an offer, and then actually an acceptance of the offer.
Exactly.
Which I guess the one question that I have, I want to, for this point right now, avoid or not talk about the first two hurdles, but the third hurdle is where is the acceptance following the offer? And I don't see any of that, any acceptance or really any communication by the parties, any of the parties, in response to whatever this negotiation went through in the form of these multiple emails. Is there an offer where any party to this alleged agreement accepts the terms and specifically the term of unanimity?
Yes, and
Where's that?
you have to. It's in the exchange of emails, which everybody participated in. The Goulians said, we'll do whatever. So they accepted whatever anybody came up with.
Is the word accept used? Is the word accept used in any of these emails?
I can't answer that, Judge. I'm sorry. It didn't occur to me because my client, he agreed to do what Mr. Day and Seaberg came up with after all of the efforts for 2 months to get guidelines.
Is the word agree used?
Yes, my client in his, and I've got it cited here, on record 811, which follows, we'll go from 804 to 811, and there's a whole series of emails that show that my client agreed that Mr. Day could build the 10-foot extension. The actual documents, which I've cited in my brief, which were submitted to the state by Mr. Spar, showed that the roof line was supposed to stop at the end of the boat slip. Instead, Mr. Day extended it all the way to the end of the dock, which means that he has now commandeered a portion of the common dock area. And the agreement was, we were going to submit this to the state. Everybody's got a boat slip allocated. Everybody has the right to roof over their boat slip to the extent that of the boat slip, but no further. So when you say, was there offer and acceptance? Yes, there was a series of negotiations. There was an offer by Mr. Day to keep this 10-foot section open, which if you'll read, I mean, the summary judgment evidence is this is a long and convoluted process, but my client's deposition and Larry Adams and my client Marcia Adams' deposition were taken. They both filed affidavits in opposition to the motion for summary judgment from the other side, all of which attach the emails and goes through a chronological discussion of exactly what happened. So was there an offer? Yes, there was an offer to allow Mr. Day to build a dock extension and allocate the boat slips, and they agreed and paid for getting electricity to the dock. That's the beginning of it. And then what happened was Mr. Day decided he wanted to do something different. So after the permits had been granted and before anybody knew it, he decided, I'm going to go ahead and put the dock, the roof line over to the very end of this dock and essentially cut off the rights of everybody else to use it. And so that's the gravamen of the problem here. And was there a contract? Yes, they agreed. We all submitted this.
I understand what you're saying about offer and acceptance. Could you address the other element of bargain for consideration? It wasn't clear on me yet what the nature of that consideration is.
Well, the nature of the consideration is exchange promises in exchange for promises about how we're going to build the dock. I'm having a hard time with the concept of bargain for exchange when you've got joint owners, they have a right to use the dock. How are we going to do that? The negotiations and the agreement on what exactly everyone can do without interfering with anybody else's right is an acceptance, and it's performance. The whole concept here is gotten perverted, and I use that word lightly, but it's gotten turned around because Mr. Day decided he wasn't going to live with what was put on the application for the submerged lands modification lease with the state of Florida. I will sit and come back in a minute.
Thank you.
Excuse me.
May it please the court,
You may proceed.
counsel. My name is Nick Martino, Your Honors, and I represent the appellant Epic Shores, and I would ask that I be able to use 12 minutes, and then my co-appellee will address the last 8 minutes.
Okay, I'll let you divide that time up.
Yes, Your Honor. Thank
Okay.
you. This case ultimately boils down to the ability of a homeowners association to abide by its governing documents. And in my time before the court, I would like to briefly address the preservation issue because I think it shapes everything else. And then I'll turn the attention to what I think is the sole issue that was preserved, which is that of the agreement that your honors were asking about.
If I could ask a couple of quick questions. The first question is, how were the 3 slips allocated? Did they flip a coin? Did they come to a mutual unanimous agreement? How were the 3?
The slips themselves would all be governed by use as far as the ARC, the ARC board. And I think that might be something that my co-counsel or my opposing counsel here is missing, is that the rights that one has here, just to address.
My question was, how was that decided? There's an L-shaped dock.
Yes, Your Honor.
Here's the land, comes down to the water, cuts over L-shape,
Yes, Your Honor.
90-degree angle.
It's
And
not
then there-
indicated.
And then there's one slip that's on the entrance of the dock. And there's 2 on the leg of the L, one on either side. How was that determined, and how was it determined that who gets which slip?
The short answer, Your Honor, is that we don't know exactly from the record because it's not included in the record. I can tell the court from the pleadings that took place and the initial drawings that were submitted is that the initial slips were laid out as a part of the design. As far as which lot would govern them based on proximity, which lot would use them, that would ultimately be something that would either be agreed by owners or if there was a dispute by the Architectural Review Board.
So which of the 3 slips is the Adams slip?
The add-on slip in this context was slip 16 was the add-on slip. That's, if Your Honor is asking which one's in question here.
As I'm walking down the dock,
Yes, Your Honor.
there's one on the right. I get to the end of the dock, I turn left, there's one on the right, there's one on the left. So which is the Adams dock?
The furthest on the left, which I believe is 16, Your Honor. Tract A. Yes, which, if I'm orienting properly, would be the one on the left.
Okay,
Would be upstream, essentially.
Okay, so help me out. On the diagram, this is Exhibit F, and then there's Exhibit G in the record. One's a drawing of the dock and the slips. One is a photograph with the new roof on there. Help me understand it, and I'll let you get to your argument, but I want to understand the facts here. Because it looks to me as if you have these 3 slips. Each owner can build their own docking, they can put in their roof, they can, whatever they want to do as long as it's approved by the Architectural Review Committee, right? So in this case, from what I can tell, the piece of the roof that we're talking about is essentially a 10 by 13 foot roof that was built over 10 by 13 feet of additional docking. Is that correct?
That's correct, Your Honor.
Okay, so we're only having a discussion today about the roof and not about the additional docking?
That's correct, Your Honor, yes. The dispute that was raised by the Adams was that the additional length of the roof in some way impaired their rights and their easement.
Well, they're correct in that if they built the same size roof, a 13 by 25 foot roof, this additional roof that was added on infringes upon that. They cannot build the same size roof as their co-owners or
That would be correct, and candidly, Your Honors, I haven't physically seen it, but from the drawings and from what I can draw from the record, that's true, but that's something that would be regulated by the HOA, by the Art Committee, and that's the purpose of them, is that these owners, the Adams, would come before the Art Committee and say, we don't want this because one day we might want to do the same. The issue here was that Ms. Adams, the appellant, was on the Art Committee, and there was a proper hearing, and she was outvoted. And now she takes litigation to try to undo what the Art Committee has properly done as a part of the declaration.
Well, if you look at the diagram in the photograph, Adams' slip is not infringed upon by the roof, from what I can tell. The roof goes over on I forgot the name of the third party, who's not a part of the appeal.
Gillian?
Pardon me?
Gillian?
Gillian, okay, so the Gillian slip is the one that really perhaps has an intrusion.
And that's what the trial court found, is that there's no infringement on the Adams' rights whatsoever. And that's really what they've taken issue with here, that there was a second argument made about riparian rights as a part of the reconsideration, which weren't really focused upon in the initial motion for summary judgment, although we don't have transcripts for that. But the check and balance here is always going to be the declaration, and then by way of the declaration, the rules and regulations that the Art Committee enforces. And I want to correct something that I think might go somewhat to what Your Honor is talking about. Appellant counsel stated that there was no approval of any of this, and I'd like to point the court's attention to record at 547 to 548, which is the initial HOA announcement with the fact that the initial plans were voted on and approved. Then, when there was this additional extension that wasn't in the original plans, there was a second as-built proposal submitted, and that as-built proposal was also approved, and that's on record at 497 and as a part of 652. Both were minutes transmitted by the HOA president showing that the Art Committee had approved these. So nothing improper was done here. What the appellant seeks to do is to undermine the trial court's ruling, which I would contend, having seen a lot of these association rulings by trial courts, is a very specific and a pretty fine order as far as review for this court. As a part of that, just addressing this agreement issue, we briefed the preservation part pretty clearly, first in the Applegate case, that there is no transcript here. So if there's any factual questions, Your Honors, the case law is, I think, fairly straightforward, that the court is going to err on the side of the trial court's findings. The second part of this is that the motion for rehearing only raises 3 issues, and really two of the issues are the same. It raises that it was contrary to the manifest weight of the evidence based on this agreement that supposedly existed. Secondly, it specifies the agreement was never considered by the trial court. And then third, it raises a strange issue, I would say, that the court fails to provide them guidance on future potential arguments, which I don't think is anything that the trial court would be inclined to do in a summary judgment motion. So addressing the agreement issue together on the preservation front, and my co-counsel will get into some of these factual matters in more specificity, but I did want to address the conversation that Chief Judge Hollis, you were having, and also Judge Pratt, you asked about bargaining and exchange. The simple answer is there wasn't any. And the court asked appellant counsel, where is the acceptance in these emails? And he didn't answer that question, or couldn't answer it, because there is no acceptance. In fact, if the court would ever look, when the court looks at the specific text of the emails, appellant Adams actually says in the email, and this is record page 157, Mr. Adams says, "I'd hoped, as I stated in my request for a meeting, to have an open discussion, come to a final decision, and move on. The lack of desire to meet tells me this is not easily fixed." Mr. Gillian, which only replies at the end of this email chain, says, and I quote, "It seemed to me we were close to having an understanding a few days ago." That's record at 156. Now, that doesn't even factor in the idea that the association was never part of any potential discussion of an agreement. And as the representative for the association, and I'm sure your honors have dealt with in the past, associations have a right and interest in preventing homeowners from forming agreements that undermine the declaration. I'm not saying this agreement would do that. We never got to that point. But what I am saying is that if this agreement came to the association, they would have an interest in being a part of it because it may require an amendment to the declaration itself. That never occurred here. There is no agreement. This is a legal fiction that was created by the appellants in order to try to overcome the declaration. But tying back in the preservation issue, I think is important here. The issue that was preserved by appellant in their motion for rehearing, the motion for reconsideration, which was taken as a rehearing, was that the trial court ignored the question of whether there was an agreement. The trial court's order specifically says, and this can be found in the trial court's order, record 876 through 877, that the first issue raised was that the parties had to unanimously agree on improvements constructed. And then the court goes through a paragraph of discussion to then say the declaration here governs, there's essentially no evidence of an agreement. The agreement, even if it existed, if the trial court had gotten there, which it didn't, the trial court still would have had to have deferred to the declaration. There is a plethora of case law that speaks to this. So I'd ask the court to consider that not only on the preservation front. I don't think the court even needs to ask the question whether there was bargain in exchange. But in the hypothetical, if bargain in exchange existed here, what the bargain in exchange would be was giving up the right to build or to challenge any building in the future in front of the ARC. That's really the only thing the homeowners could have given each other, assuming the HOA permitted it. This agreement issue was addressed again in the order following the motion for reconsideration, where the trial court said, all you're doing is rehashing the identical issues that you argued in front of me in the summary judgment process. And finally, and then I'll yield to my
Do you have a problem with the declaration and the timing of the approval by the Architectural Review Committee? Technically, the approval of the as-built dock was not done until after it was already constructed. How is that not inconsistent with and in violation of the declaration, paragraph 53?
Yes, Your Honor. Two parts to that answer, if I may. The first is that as-built reviews are very common in the association area. There is a process by which one can challenge as-built approvals after the fact, and actually, appellant tried to raise this as a selective enforcement issue, which would be the route. However, the case law that we cite to in the answer brief, which there's a significant amount of it, is clear that selective enforcement, there has to be a solid record made that as-built approvals are being done for certain residents and not others. There was never any record of that. There was never any argument about it. There was simply one reference to selective enforcement, to which the trial court said there's no evidence of selective enforcement here whatsoever. So as-built is very common, and even if there had been a proper challenge to as-built, that didn't occur here. It wasn't pled in the complaints. It wasn't raised in any of the responses, and it was not raised in any of the summary judgment arguments. And I would say, Your Honors, based on what we do have in the record, a hindsight review, this as-built review process is pretty common. Engineers get in, they start building, they find out something has to be a few inches or a few feet one way or another. They couldn't have realized it till they got there, especially on the water. And it's very common for associations to go back and do as-built reviews. And if I could just point out one other item and then yield to my co-counsel, as a part of that as-built process, had it been raised, there would have been a plethora of defenses that the HOA could have raised, including this idea of economic waste, not having to compel somebody to waste and tear down a project that really doesn't have any infringement on any other rights. And if, unless the court has any other questions, I'll yield the remainder of my time to my co-counsel.
All right.
Thank you, Your Honor.
Thank you. counsel, you have a little north of 7 minutes.
Good afternoon, Your Honors. May it please the Court. My name is Summer Reed, and I, alongside my colleague Bill Cobb, represent appellee John Day in this matter. Your Honors, at this point in the afternoon, you've had a chance to not just hear from counsel for appellant, but also for counsel for appellee, being the association. As you've likely noticed from the briefs, a lot of the issues raised, and in fact, most of the issues raised by appellant address both the association and Mr. Day, and counsel for appellee, the association, Mr. Martino, gave a well-stated and very thorough legal analysis of the issues, especially regarding the agreement and the boat slips, as Your Honors had raised questions to. With that in mind, for the sake of brevity and in avoidance of repeating myself of a lot of the facts and the legal issues that have been raised, unless you have lingering questions relating to Mr. Day specifically, I'll keep this brief with just a summary of the facts.
Well,
really.
if I could, I asked some questions early on that I didn't get answers to about how were the slips determined? I mean, who got what slip? Do you know? Is there anything in the record how that decision was made?
There's nothing in the record, Your Honor, and frankly, I believe that was well before the turnover phase that those were determined. But I can suggest that it's not in the record of how those were identified before all of these issues arose.
I mean, I'm not sure which of the 3 lots would be the most preferred lot, or slip, I should say. It looks like the Day slip is probably the most desirable because it's right fronting out furthest on the dock, away from the other 2. But again, you just don't know how that came about. The question I have on the docking that your client added, it appears to be a 10 by 13 foot additional docking. You walk down the dock, it used to stop, and he added on an additional 13 feet, 10 feet wide of docking. Does he own that docking, or is that common access?
The dock as a whole, if we're looking to the declaration and what would be the governing authority over the dock as a whole, it is a common dock pursuant to Section 53. I don't think there have been made any assumptions or suggestions to that in particular. I think the real issue has been that overhang. I apologize.
Right. So, but the question is, who controls the 10 by 13 foot, 130 square foot additional docking that your client put in?
The entirety of the dock, whether we're looking at the extension or the existing parts of the dock, are owned by the association. And I think that is a part of, maybe if I can direct this to this being the Tract A dock, as you'll see it referred to in the briefs. I think that goes directly to maybe the reason for your initial question about who owns what slip and what may be preferred. Tract A in and of itself, not the Tract A dock, but Tract A, was given to I say given to, the use and access rights are given to these 3 owners, and I think this is an important big picture point of this argument. This is a more modest association. There's only 16 units as a whole. Of those 16, all of the units have water access, excluding 3. Those 3 unit owners, or lot owners as we refer to them, are the sole people that got the use and access rights to this dock. But I think that's an important distinction under Section 53, and as we're all aware, the dock itself is owned by the association. It is to be shared amongst the, it's for use of the 3 owners. But Tract A that leads to that dock, each of those 3 owners have access to cross over that property.
That's the real property you're talking about.
Correct.
And that has nothing to do with the case, right?
I do think it leads to where you were going with the first question as to the rights of the owners, depending on where you're looking at the dock in and of itself, of the configuration, because of the riparian rights argument.
There's a list of enumerated rights, and among that list, and there's a catch-all that says all other rights regarding the Tract A dock, but it also includes construction and reconstruction. So could you speak a little bit to that about what the significance of those rights should be and how they operate under paragraph 53?
I don't think there's really been any issue raised on appeal of whether adding to the dock, whether adding the overhang, whether adding electricity, whether any of those issues constitute an issue of reconstruction versus construction. There's no question under the declaration, the express language that is the basis of this whole argument, that there is a right to construct on this dock. The real issue is whether or not there is either express language in the declaration or there is an agreement, as appellants argue that these 6 emails constitute an agreement, that there has to be unanimous decision-making as to this dock. And the record is devoid of any evidence that there has been an agreement that unanimous decision-making has to be made. And I think that really is the substance of the argument here on behalf of appellees, is the record simply has no evidence to support that, and that is what supports this court affirming the lower court's decision. When we back all of this up, as Your Honors raised early on in this argument, if we're looking at simply offer, acceptance, and consideration, there is none. And if we back this up even further to Section 53 of the Declaration and its amendments, as in the record, there is no evidence of unanimous decision-making being required, so there's no legally enforceable and binding agreement to the parties. And that is really the basis of why appellee here is asking that Your Honors affirm the final judgment. Unless Your Honors have any additional question, that is...
On Exhibit F, this is the diagram that shows the 3 slips. Would you agree with me that is it Julian, if they decided they wanted to build a roof that's depicted on here, the 13 by 25 foot roof, that they couldn't now because your client's construction of the roof infringes upon their space? It's not much. It looks to be like 18 by 18 inches, but they could not build the roof that is on this diagram.
Without necessarily having measured exactly what the opportunities would be, I think this takes us back to that same question. Could they physically, I'm not 100% sure, frankly, based off of the dock parameters in and of themselves, but the issue would be one that they would take, as my co-counsel stated, they would take to the ARC, they would take to the board, and they would have permitted accordingly, all of which here Mr. Day did. Whether we want to take that back to when he did it the first time or when he did it with the as-built circumstance, it was approved by the governing entities that had to require it. The only dissenting votes through this entire process of anyone was Mr. and Ms. Adams and their roles on the ARC and the board respectively.
And to clarify, if the Adams and the Julians want to go on that 10 by 13 foot new additional docking, they're entitled to do that?
Yes, Your Honor. To my understanding, there's been no argument over that in the record or otherwise. Thank you, Your Honors, for your time. Appellee would respectfully request that you affirm the trial court's final judgment.
About 5 minutes, Mr. Grassley.
Thank you. Judge Makar, your last question. Mr. Day has, let's talk about what the record is in the summary judgment hearing. We got filed depositions from my clients. We have 2 different affidavits filed in opposition to the defendant's appellee's motions for summary judgment. Those constitute part of the record evidence. The court's leg is being pulled with the preservation issue. Who needs I'm somebody who tells all his trial counsel, even if you're going for a motion to set, please take a court reporter so we know what was said. But in a summary judgment hearing, the Applegate analysis doesn't make any sense. You've got the record for summary judgment purposes. My client testified that in 2 different occasions, Mr. Day has said, you can't use any part of my roofed-in area. Your rights stop where my construction begins. That's part of the record. The actual part of the record, the claims that counsel for the association made that, well, you got to go through the ARC and do this the right way under the covenants and restrictions. I agree. It didn't happen, and the reason it didn't happen is because the president of the association stopped the process, made a deal with Mr. Day on how he could go ahead and do the modifications that he was seeking and cut out the ARC and the board. The important thing that I want the court to understand is this as-built issue is the subject of the amended complaint, because once my client sued when Mr. Day decided he was going to build something that wasn't ever agreed to and wasn't permitted, they had this meeting without inviting my client, the board member, and my client, the ARC member, and agreed to this approval as built. That was after the complaint was filed, and that's why there's an amended complaint with a count 2 saying make them take it down. They tried to go after the fact, after we all have a vested right in how we're going to proceed with this dock.
Counsel, I don't see where the new roof or the docking in any way infringes upon the Adams slip.
It doesn't infringe on the Adams slip. It infringes on the Adams right to have an open dock except for as agreed to and permitted boat slips, because the 10-foot was represented. And again, the record evidence on this issue is in my client's plural depositions and affidavits. The second affidavit's filed in opposition
Do your
to.
clients oppose the additional docking?
No, they agreed to the 10-foot because it was represented to them. And again, the record evidence shows that they agreed to this because...
I'm struggling because, okay, you now have a substantially larger dock for everyone to go upon.
Exactly, except that it's not for everyone. The additional roofing...
We just heard that it was.
What you heard is contrary to what the record facts say, Your Honor.
Okay, well...
Or there, at best, there's a
so many
factual
people
dispute.
can go on this lot, or on this additional docking. What's the beef about having it have a roof over it? I don't understand that. Why is that?
Because it interferes with my client's rights of view and the openness of the end of the dock. And that's something, if you look at Marcia Adams and my client's deposition testimony, she points out that that was one of the main concerns of the ARC was to have uniform sight lines so that the end of the dock would be open so that everyone would have a beautiful view of the river.
Does your client have a boat at the slip?
Not yet.
Has she ever had a boat at the slip?
Not yet. This was a new development. They picked the slip first, and that's another issue. Read my client's depositions. That allocation of the boat slips happened all along the way. My clients picked theirs at the closing of theirs, and then Mr. Day came in and decided he wanted everybody else's, and it got worked out, but that was subject to negotiation and agreement, and that's how it happened. The preservation argument fails to overlook the actual arguments made in the motion for rehearing filed by my client's trial counsel, which points out that the easement that my clients enjoy is the earth to sky, which they are entitled to an open view of the river, which is exactly what the problem with this 10-foot dock that now has been covered over with Mr. Day's boat slip to make it appear, and he in fact has said, this is mine.
Is it the view from their slip or the view from their home?
Both. The track A is the Uplands property, but there's no logical or legal reason why somehow you could build obstructions of the views over the objections of some of the other lot owners on the dock. And that was the whole point of this agreement. We'll extend the dock 10 feet, but then Mr. Day decides he wants to cover his portion. His boat slip's roof is going to extend over that portion. Your Honors, at worst, there should be a remand for evidentiary hearing on all of this, because the obfuscation that has permeated this is made even worse because of the fact that these parties worked on this for several months. It's not just the isolated emails that decided to in the briefs and an oral argument here today by the appellees. The actual evidence of what happened, my client's version of it, would contradict everything the trial judges said, including the indefensible interpretation of Section 53 that nobody has any responsibility, which is exactly what appellee's position is. Thank you, Your Honors.
Thank you. It's a well-argued case, and we are, in a few minutes, we're going to, one of Judge Pratt's clerks is going to be sworn in, oath of attorney, so everybody is welcome to remain if they so desire, and I will let Judge Pratt take it away.
Sure. I can see them now. We have my law clerk, Raymond Yang, both of his parents visiting us from all the way from California, and his cousin visiting from the D.C. area. Great to have all of you, and awesome to see your family's support. I guess I'll say just like a couple words about law, the legal profession, what it means to be an attorney, and then we'll make you into one. Law for many is a livelihood, but I think for all of us, it's a calling and a responsibility. And, in every version of the oath that I've seen, and I haven't actually looked at California's yet, so I don't want to, sort of embarrass myself by this being the exception, but every version that I've seen so far talks about the fairness and equality of the law and its application without respect to persons, doing equal justice, to those who have wealth and those who don't, those who have status and those who don't. And the equal application of law is an essential ingredient to what makes our country so free and so prosperous. And I'm especially enthused to see that Raymond comes from a family that speaks more than one language, and to see that you're going to become a part of our legal system, I think really speaks to one of my favorite things about this country. And I'm honored to swear you in. And I will, I guess, take a look at the oath. We can maybe do this down in front. That's how these things are normally done, right?
Yes, in the will, yep.
It has a abstain from offensive personality in it.
Raymond is almost a perfect law clerk. Sorry.
Ben,
A blue one? You want a blue one?
what's California required?
Yeah. Is there an ink requirement?
So I guess we'll do the oath and then have your family come up later, or would you like them up here now? Right now, is your plan taking the oath? Yeah. You all want them up? Wherever you sit. Let's do that.
Might bring the microphone over too.
Say is so ordered.
Will that mic spin around so we can use?
Judge Pratt, step back here and you can use that so it'll pick it up.
That's right. YouTube is watching too, so we need the microphone. Okay. If you could repeat after me, raise your right hand. I, Raymond Yang,
I, Raymond Yang,
solemnly swear
solemnly swear
that I will support the Constitution of the United States and the Constitution of the State of California,
that I will support the Constitution of the United States and the Constitution of the State of California,
and that I will faithfully discharge the duties of an attorney and counselor at law
and that I will faithfully discharge the duties of an attorney and counselor at law
to the best of my knowledge and ability.
to the best of my knowledge and ability.
As an officer of the court, I will strive to conduct myself at all times
As an officer of the court, I will strive to conduct myself at all times
with dignity, courtesy, and integrity.
with dignity, courtesy, and integrity.
Congratulations.
You need to adopt that.